Xiao. You have no previous convictions in this country, but you were convicted of the same offence in Australia. The final conviction in Australia, on a retrial, was on the 3rd of May 2023. Importantly, the offence in Australia had been committed much earlier than that. In fact, the offence in Australia was committed on the 27th of April 2015. This was about 16 months before the offence in this country, for which I have to sentence you now. There were some similarities between the two offences. I now set out the facts of the case. You were convicted in this court of manslaughter in relation to the tragic death of Danielle Carr-Gomm on the 20th of October 2016, when she was aged 71. Danielle Carr-Gomm had type 1 diabetes. She had been prescribed insulin to manage her condition. She had to take this insulin by subcutaneous injections, which she administered herself. The jury received evidence about Mrs. Carr-Gomm, including a recording of her speaking, as well as other written evidence and testimony from her son, Michael. It is clear that she was a youthful, vigorous 71-year-old who should have had a lot of life still to live. Her untimely death was a tragedy for her and for all those who loved her. Mrs. Carr-Gomm was diagnosed as a type 1 diabetic relatively late in life. She was a committed vegetarian. She did not like taking insulin, and she did not like the use of needles. She strongly wanted to find an alternative treatment that would enable her to end her use of insulin injections. She attended a residential workshop in October 2016 led by you. The workshop was on the topic of Pai De La Jin. You claimed that Pai De La Jin was an ancient Chinese healing practice which you had rediscovered and which you had been practicing and promoting for some years. Pai De La Jin involves slapping, referred to as Pai De, and stretching, referred to as La Jin. Under your regime, these techniques were undertaken in combination with fasting. You claimed that your method would cure nearly all diseases, perhaps all of them. You specifically claimed that your method could treat and cure diabetes, including type 1 diabetes. You said that diabetes and many other diseases were caused by toxins, and that your regime would expel these toxins from the body. By contrast, you claimed, conventional Western medicines were poisonous and only increased the toxins in the body, making people worse, not better. You discouraged your followers from using any conventional medication, even when it had been prescribed by a doctor. You claimed that the severe bruising that resulted from your followers being repeatedly slapped about their arms and legs was a good thing, because it showed that toxins were being released from the body. When your followers suffered during fasting with symptoms such as tiredness, nausea, confusion, even pain, these things too, you said, were signs that toxins were being released from the body. You said that this suffering was something that had to be undergone for your method to be successful. You described it as the darkness that precedes dawn. In other words, you told your followers that all the symptoms that others might recognize as a medical emergency were both welcome and necessary. The workshop that Mrs. Carr-Gomm attended took place at Cleeve House in Wiltshire. It was due to last 5 days in total, including a 3-day optional fast. The fasting days were Monday the 17th, Tuesday the 18th, and Wednesday the 19th of October 2016. Mrs. Carr-Gomm took part in the fast. The the jury heard evidence about a conversation that took place towards the end of the workshop sessions on the first day of the fast, so probably between about 5 p.m. and 7 p.m. on Monday the 17th of October 2016. Mrs. Carr-Gomm told the group, including you, that she had stopped taking her insulin. The evidence was that you congratulated her, saying something like, "Well done." When you gave evidence to the jury, you denied this. You acknowledged that Danielle Carr-Gomm spoke to the group, including you, at about this time on the first day of the fast. However, excuse me. However, your evidence was that all she said was that she had reduced her insulin by half. You said that you responded saying that this was good as long as she was reducing her insulin gradually, testing her blood sugar and checking her health and adjusting her insulin dosage accordingly. In the light of the jury's verdict, I am certain that they rejected your evidence and accepted the prosecution case. The totality of the evidence to this effect was overwhelming. I therefore sentence you on the basis that you knew from late in the afternoon of day one of the fast that Danielle Carr-Gomm had stopped taking her insulin. Furthermore, you made it clear to her that you supported this. On the second day of the fast, Mrs. Carr-Gomm was weak. She was unable to take part in group activities. This was noted by others, and there was evidence that it was widely discussed. You said that you had no idea about this. I am sure that this was not the case, and that you knew, on day 2 of the fast, that Mrs. Carr-Gomm was too weak to take part in any group activities. She was the only participant who was affected in this way. During that evening, and into the early hours of the morning, she was obviously unwell. She was vomiting, agitated, and in discomfort to the extent that others were concerned. Her roommates were certainly concerned, but so too were the resident chef who heard her sounds of distress, and one of your assistants who went by Nancy and who spent several hours in Danielle Carr-Gomm's room trying to calm her. On day 3 of the fast, Danielle Carr-Gomm was too unwell to leave her room, or even to get out of bed. You visited her for a while in the morning, I assume having been informed by someone that she had been unwell in the night. You returned at lunchtime, trying to persuade her to drink and eat. You may also have made a rather brief and half-hearted effort to get her to take insulin, but, you said in evidence, with no real conviction. You then left to lead the afternoon Pas de la Gin sessions. It follows that for most of the day, Danielle Carr-Gomm suffered, alone, in her bedroom, while the Pas de la Gin sessions went on downstairs, conducted by you. In the evening, you again returned. This time, you persuaded her to drink some ginger tea and to eat a little couscous. You did not make any further attempt to get her to take insulin. You stayed on and off for several hours. Mrs. Carr-Gomm's condition on day 3 of the fast was worse than it had been on day 2. She had to be helped to sit up to vomit. Her face was paler than on the previous day. She was drooling. Her agitation was undoubtedly more pronounced, and it was uncontrollable. In the course of that day, her roommate was so concerned that she would fall out of bed that she moved a chair to try to prevent this from happening. Later on, in the evening of day 3, you and others were so concerned about her falling out of bed that you moved her mattress to the floor. It is not apparent how clearly Mrs. Carr-Gomm was thinking or speaking on day 2 of the fast, or in the morning of day 3. However, over time, and especially during the evening of day 3 of the fast, it became obvious that she was incapable of either thinking or speaking. Eventually, she became quiet and stopped moving. This was not because she had been soothed by you or because toxins had left her body. It was because she was in a diabetic coma caused by ketoacidosis. You departed probably between 11:30 p.m. and midnight, leaving her in her room in that condition. Eventually, during the early hours of Thursday, the 20th of October 2016, Danielle Carr-Gomm died. Crucially, this was not an isolated incident. There were 2 important precursors. The first was the death of Aidan Fenton in Australia. He was a boy of 6 years old who was a type 1 diabetic. His parents were persuaded to take him to a workshop led by you in New South Wales in April 2015. The evidence in the prosecution that followed in Australia was that you positively exhorted Aidan's parents not to give him insulin and not to test his blood sugar level. During the course of the workshop in New South Wales, and in particular during the fast, Aidan got progressively weaker. He could not walk or stand. He started vomiting. He was in obvious discomfort from an early point. Eventually, he was in extreme pain. Ultimately, he died. You were interviewed by the local police on the following day, but left Australia almost immediately after this. The second important precursor involved Danielle Carr-Gomm herself. The workshop at Cleve House was not the first Paide-Lagen workshop that she attended. She had attended a similar workshop in Bulgaria in July 2016. In other words, about 3 months before the workshop at Cleve House. At the workshop in Bulgaria in July, just as at Cleve House in October, she stopped taking her insulin. On that occasion, however, you actively intervened, spending several hours persuading her to take her insulin. She initially refused, but your efforts to persuade her persisted over several hours and ultimately succeeded. Taking insulin saved her life, and that must have been clear to you. At the end of the workshop in Bulgaria, after she had recovered, Danielle Carr-Gomm made a testimonial in support of you and in support of Paide-Lagen, in which she addressed you directly and in person as, I quote her exact words, "a messenger sent by God," unquote. This testimonial was recorded on video, and it was later found saved on your phone. You were clearly pleased with it. You were also clearly aware of the influence that you had over Mrs. Carr-Gomm. You must have been aware of the responsibility that comes with such influence. During the trial, the court heard evidence from Dr. Ti-Jung Tang, the General Secretary and Professional Conduct Executive of the Association of Traditional Chinese Medicine and Acupuncture in the UK. Dr. Tang made it clear that Paide-Lagen, as taught by you, was not recognised as a treatment by the association or its members. He said that you had never been a member of the association. He also said that while traditional Chinese healing methods may differ from Western medicine, no accredited or conscientious practitioner of Chinese healing would ever recommend that a patient should stop taking medication prescribed by a conventional doctor. The prosecution case against you was that you owed a duty of care to Danielle Carr-Gomm as the person leading the workshop at Cleeve House, and that you were in breach of that duty, and that you failed to make any reasonable effort, either first, to persuade her to take insulin, or second, to get emergency medical assistance. The prosecution said that you should have told her on the 17th and the 18th of October 2016, that is on day 1 and day 2 of the fast, to take insulin. You should have made the same persistent effort with this that you had in Bulgaria. Then they said that from then on, over the rest of day 2 and throughout day 3 of the fast, you should have taken steps to get an ambulance. They said that your failure to do either or both these things caused Danielle Carr-Gomm's death, and that it amounted to gross negligence. This is the case that the jury have accepted in finding you guilty. I am certain that you were in breach of your duty to Danielle Carr-Gomm in both the respects asserted by the prosecution. In your evidence, you accepted that you knew that Danielle Carr-Gomm was a type 1 diabetic, and that if she did not take her prescribed insulin, she would die. As I have already said, it was clear from the totality of the evidence, and the jury undoubtedly decided, that you knew that Danielle Carr-Gomm had stopped taking her insulin. You knew this because she told you so. Directly, face to face, late in the afternoon of day 1 of the fast. It follows that you knew that this would eventually be fatal. No one else at the Cleeve House workshop had the same knowledge of Danielle Carr-Gomm's condition or of the consequences of her stopping her insulin. Excuse me again. No one else was leading the Pai de la Jin sessions or directing whether and how people should take part in the fast. No one else claimed, in effect, to be the world's leading expert in Pai de la Jin. No one else was regarded by Danielle Carr-Gomm as, quote, a messenger sent by God, unquote. In your defence, you relied on a document headed Disclaimer, signed by Danielle Carr-Gomm, in which she confirmed that she discharged you and the others involved from any liability, duty or responsibility. However, the same document also purported to confirm that she was aware that Pai de la Jin was not meant for medical treatment, nor could it be used to diagnose or treat any illness or health problems. But you repeatedly claimed that it was effective for all these purposes. The disclaimer document also purported to confirm that Mrs. Carr-Gomm was free from any illness that could aggravate or endanger her life. However, you knew from the experience in Bulgaria not only that she was a type 1 diabetic, but also that she wanted to use Pai de la Jin to help her stop taking insulin. And then, from late afternoon on day 1 of the fast, you knew, because she told you so, that she had stopped taking her insulin. The jury evidently concluded that this document did not represent the reality of your relationship with Mrs. Carr-Gomm. That would certainly have been my conclusion on the evidence that the jury received. What all this means is that you knowingly and deliberately allowed Danielle Carr-Gomm to continue with her fast, which in her case meant not merely abstaining from food, but crucially also abstaining from insulin. You congratulated her when you first learnt that she had stopped taking insulin. Later, on day 3 of the fast, you may have made a token effort to persuade her to take insulin, but this was, at most, a token. It was too little and too late. Furthermore, you failed to summon emergency medical care, even when you, of all people, should have known that she was bound to die without insulin. In sentencing you, I have regard to the Sentencing Council guideline for this offence. and for the guideline on the imposition of community and custodial sentences, as well as Part 6 of the Sentencing Code. In assessing your culpability, first, I regard this as a case where you continued in your breach of duty to Danielle Carr-Gomm in the face of her obvious suffering over several days. Second, the offence was particularly serious because of the very high risk of death, which you knew of. You must have been actively conscious of this risk in the light of the death of Aidan Fenton in Australia some 16 months earlier, and also in the light of the near death of Mrs. Carr-Gomm herself in Bulgaria just 3 months earlier. This was blatant disregard of a very high risk of death. The prosecution suggested I should also have regard to a third factor pointing to high culpability. This was that, as the course leader and, in effect, the inventor of Pai de la Gin, you can be said to have had a leading role. You carried the others present with you, your assistants on the course, and the others paying to be there. They all put their faith in you and depended on you. You knew this, and it seems to me, enjoyed it. However, this is not a case where you led other people to behave criminally. This third factor, therefore, is not of much significance, at least in terms of culpability with regard to the Sentencing Code. Nevertheless, taken together, these factors, or at least the first two, indicate high culpability, that is Category B, for the purposes of the guideline for the offence. The category starting point is 8 years, with a range of 6 to 12 years. It goes without saying that the offence is so serious that it requires immediate custody. I have considered whether there are additional factors that increase the seriousness of the offence. The earlier offence in Australia and the fact that you ignored previous warnings, that is, the events in Australia and in Bulgaria, are matters I've already taken into account in assessing the offence as Category B. I'm conscious of the need not to double count. However, it seems to me that the circumstances of the events in Australia and in Bulgaria, and their incredibly strong overlap with what happened at Cleeve House, means that they go beyond mere warnings. When coupled with your frank admission that you knew that Danielle Carr-Gomm's cessation of insulin would result in her death, this seems to me a case where your culpability is worse than the norm, even in the context of Category B. I've also considered whether your promotion of Pai de la Gin may have been at least partly motivated by the prospect of material gain. I've received no real information concerning the financial rewards that you made by conducting workshops, such as the one at Cleeve House, nor from the sales of your book on the subject of Pai de la Gin. You accepted in evidence that some sort of fee would have been payable, but it never became clear what this might have amounted to. I've received statements provided by a number of your friends and followers who all say that you are a sincere person with very limited material needs or aspiration. They say that you have never really been motivated by money and that your main concern is to help others. Ultimately, I am not satisfied that you were really motivated by money. Having said that, I'm also not convinced that you acted only out of altruism. I have the firm impression that you actively enjoy the respect that being the founder of the Pai de la Gin movement has brought you in the eyes of some people. Because of the earlier events in Australia and in Bulgaria, and their very great significance for your culpability, it is necessary for there to be an uplift of 2 years above the normal category starting point. It makes no difference whether this is treated as a case where the facts demand a starting point above the normal one for category B, or whether the relevant matters are treated as contributing by way of aggravation. Either way, this takes the sentence to 10 years. I've considered what factors reduce seriousness. It's been suggested that you were remorseful. I see no real sign of true remorse. It is clear from your evidence during the trial that you continue to practice and promote Paida Lajin, even now, while in prison. You still strongly believe in its effectiveness. You also still strongly believe that Western medicines are toxic and that their use should ideally be avoided. You said in evidence that the death of Aidan Fenton, the child whose death you caused in Australia, haunted you every day. I was not impressed by the sincerity of this evidence, not least because it was so utterly inconsistent with the actions that followed, resulting in the death of Mrs. Carr-Gomm. I'm sure that you would prefer it if Aidan Fenton and Danielle Carr-Gomm had not died. However, it is far from clear to me that you accept responsibility for their deaths, or that even with the benefit of hindsight, you would have acted any differently in any material respect. On the contrary, in your evidence, you denied that you had ever told Aidan's parents to stop his insulin, and you said that you made it clear to Danielle Carr-Gomm that she should be cautious about reducing her insulin and should test herself, check, and adjust her insulin dosage accordingly. I have explained that the jury evidently rejected this evidence, and I have further explained why I consider they were undoubtedly right to do so. By maintaining this false account of the circumstances of both tragedies, you in effect were suggesting that Aidan's family were the people really responsible for his death, and that Danielle Carr-Gomm herself was the only person really responsible for her death. This self-centered blame shifting was both repugnant and disturbing. I received this morning a handwritten letter from you, dated the 3rd of August 2024, in which you have emphasised at some length that the trial process that you underwent here in Winchester has changed you. In particular, you say that some of the questions you had to answer and some of the issues you had to confront have made you look again at your past beliefs and patterns of behaviour. You say that you now see that you made mistakes. I hope that this is so, but I find it remarkable that even 2 deaths were not enough to bring about these reflections. It took not 1, but 2 trials and convictions, and a period of nearly 8 years in custody, and was only given expression by you very soon before you expected to be sentenced. I now turn to personal mitigation. As I've already noted, I've received statements from a number of supporters, all friends and adherents of Paida Lajin. There are no statements from your family, although I understand that you have 2 adult daughters, as well as an elderly mother in the People's Republic of China, whom you have not seen for some time. In fact, I understand you had not visited China for some years, even before your imprisonment in Australia. Your supporters all speak of your kindness and sincerity. They express the hope that you will be released from prison as soon as possible. They all appear to share the concern that you should be free, because you should be able to continue helping the world with Paida Lajin. I do not find this weighty, but I of course will impose the least sentence commensurate with your offending. I recognise that you have spent a long period in custody. A further custodial sentence of anything more than a minimal period will mean that a large portion of the prime of your life will have been spent incarcerated, separating you from others. This is simply the inevitable consequence of committing such a serious offence on 2 separate occasions in 2 separate countries. Your counsel has suggested that if the Australian offence had been committed in the UK, the 2 offences would have been charged, tried and sentenced together, and the overall sentence would have reflected totality. If you had committed an earlier gross negligence manslaughter in England 16 months before the death by manslaughter of Mrs. Carr-Gomm, it is certainly possible that the 2 offences would have been charged, tried and sentenced together. If so, they would have attracted consecutive sentences, and the totality guideline would have been taken into account. However, I do not see that I should pretend that this is what has happened. On the contrary, you committed an offence in Australia, you then continued with your Paida Lajin courses and committed another offence in similar circumstances in this country. I have to sentence you only for the offence in this country. In doing so, I must reflect the gravity of your offending in this country. The fact that you had previously been responsible for the death of a child in Australia makes the offending in this country more serious, not less serious. The sentence imposed by the court in New South Wales is the business of the Australian judicial system. It is not my concern. It cannot be right for me to consider what sentence I might have imposed for that offence if it had occurred in England. But that is what your counsel's argument really amounts to. I reject that argument. All in all, there is no mitigating factor that requires me to reduce the sentence below the term that I have reached so far, one of 10 years. Now I turn to dangerousness. I chose to sentence you without a pre-sentence report because the unusual nature and circumstances of your offending means that there was no prospect that I would learn anything from a pre-sentence report that I had not learnt in the course of the trial. Counsel did not seek to dissuade me from this course. You have never committed any offence other than the two relating to the deaths of Aidan Fenton and of Danielle Carr-Gomm. I am sure that you do not present a danger to anyone, save in relation to Paida Lajin. However, I see no chance that you will renounce the practice of Paida Lajin. On the contrary, I am certain that you will continue to practice it or seek to do so, both while in prison and after your eventual release. Furthermore, I am concerned that there is a real risk that, in doing so, you may actively or tacitly encourage your followers to reduce or stop their medication. I have heard your counsel say that you will not do this, and I have read and thought about your recent letter. However, all the evidence I have received at trial about you and from you means that I cannot accept these assurances. The letters that I have received from your supporters and the undiminished belief that they and you still have in Paida Lajin merely make me more apprehensive. I am certain that when you have finished serving your sentence, there is a significant risk that, yet again, history may repeat itself. This constitutes a significant risk of serious harm to members of the public. In this specific regard, I consider you dangerous, even though you do not share the characteristics of most other dangerous offenders. I consider it necessary to extend your sentence by imposing an extended licence period of 5 years. Bearing in mind your age now and your age when the sentence will otherwise be completed, I consider this a sufficient precaution. Hongchi Xiao, please stand up. The result is that the total sentence is 15 years. This comprises a determinate sentence of 10 years and an extended licence period of 5 years. You will be released from custody no later than 2/3 of the way through the determinate sentence, namely 6 years and 8 months. The remainder of the sentence will be served on licence in the community. You must comply with all the conditions of your licence, failing which you will be at risk of recall to prison to serve the remainder of the time in custody. That said, I need to make it clear to you and to others listening to these sentencing remarks that when you are released from prison, you will be liable to be deported. I assume to the USA, as I understand that you are a US citizen and hold a US passport. I now turn to time on remand and time awaiting extradition in custody. The period that you spent on remand will count against your sentence. I understand that this period commenced on the 1st of December 2023, and I'm told that it amounts to 371 days. That will count automatically against your sentence. Immediately prior to that, you were in custody in Australia. Having served all the time in prison required by your sentence in relation to the manslaughter of Aidan Fenton, You then spent a further 37 days in custody in Australia, awaiting extradition to this country. I further direct that this period of 37 days will also count against the sentence that I passed today. You will also have to pay the appropriate statutory charge, and you will now be taken down.